Near the end of the 2000s, the U.S. economy stumbled into the worst financial crisis since the Great Depression. The financial crisis started with the Great Mortgage Meltdown, which has created the greatest financial debacle in American history. We are Property Solutions Center. We learn firsthand about the frustrations that homeowners experience when their lender puts their home on the foreclosure express. We have started our fight years ago. We know the tricks these banks play. We've won our battles, and that's why we started Property Solutions Center. We are here to help consumers who want to stand up for their rights and get true justice. Over the past 4 years, we've helped hundreds of people and provided litigation support services to attorneys across the country. In this presentation, we will be discussing what we believe to be the biggest chink in the armor of the major mortgage lenders in the United States. We are, of course, talking about the massive fraud committed by lending institutions who have failed to follow the rules in the sale and transfer of mortgages and mortgage-backed securities. Wall Street made billions and billions of dollars packaging, securitizing, and selling mortgages over and over while ignoring the laws governing the sale and transfers of these assets. I'm sure by now you've heard about the 60-minute special about robo-signers, who reported that each sign up to 4,000 bogus and fraudulent documents every day in an effort to accelerate foreclosures that cannot legally take place. If you heard or read about this, you probably didn't believe it or were thinking to yourself, wow, I can't believe this is happening. And you probably asked yourself, how does this affect me? And what can I do about it? In this video, we hope to answer these questions for you. Should you purchase a securitization audit? In order to answer that question, you should first understand what securitization is and what went wrong. Before we proceed, it's important to know that this presentation is for informational purposes only and should not be considered legal advice. So as we go forward, let's first discuss what a securitization audit is. A securitization audit is a detailed report of the chain of title of your mortgage note. It will show violations of the New York trust law and violation of the IRS code regarding remix status. Sometimes these violations don't exist, but in most cases, when we examine a loan that was securitized, we find violations, not only of the New York trust law, and sometimes also state and federal law, but we also find violations regarding the IRS code regarding REMIC. So, what is a REMIC? REMIC stands for Real Estate Mortgage Investment and Conduit. It is essentially a tax shelter opportunity that functions very much like an S-Corp. That allows the owners of the REMIC to receive the proceeds, fourth profit, without double taxations. In other words, the profits flow directly to the owners rather than being taxed at the corporate level as well as at the distribution level. So, it's a major benefit for these particular mortgage trusts to have REMIC status. A securitization audit provides strong evidence that the party that purports to own the note does not, in fact, own it. In many cases, when we do a securitization audit, we find that the trust claiming to own the note never gained legitimate possession of the note. We also discovered that the assignment made on the note was made with the blank beneficiary, which means there was never a named person to take possession, which is a requirement under general contract law. What does this mean for you? Your note was never properly assigned. Therefore, the ownership of your note is invalid and the current beneficiary or owner does not truly own your note. As a result of this, the current beneficiary has no rights to collect or foreclose on the note. Actually, they have no rights to the note at all. This then can be used as a powerful tool in litigation against the lender. Now that you have an understanding for what a securitization audit is, it's also important to know what a securitization audit is not. It's highly unlikely, contrary to what you have heard or have been told, that a securitization audit is going to result in you getting a free house. There have been cases where judges have essentially ruled that somebody's going to get their home for free, but keep in mind that this can only happen with extensive litigation, and there were additional circumstances that were in favor of the plaintiff. A securitization audit is not a forensic audit. A forensic audit looks for violations of RESPA, the Real Estate Settlement Procedures Act, the TILA, the Truth in Lending Act, etc. A securitization audit is not a title search. A title search tells you about the liens on the property and not about the history about the ownership of the liens and underlying instruments. The next thing we want to discuss is, what is a securitization? A securitization is when a significant number of mortgage notes are pulled together into a trust, and then that trust is sold to investors who purchase the trust or shares of the trust in order to gain a return. In this process, first an originator sells a loan to a consumer and a note or mortgage is created. The next thing that happens is that a financial institution buys up a significant number of those notes, which again are guaranteed by mortgages, and pulls those loans into a large group. They then hire and work with the depositor, who's responsible in taking that pool and creating a trust or the instrument that can be sold to investors. Once that trust is created, a trustee is appointed to the pool and represent the interest of the investors that plan to buy the certificates in the trust. Those trust certificates are then marketed by an investment bank that is hired by the finance investors. So, the certificates in the trust pass through the investment bank to the investors. The investors pay for those certificates and the proceeds go back to the financial institution that pulled the loans. The financial institution that pulled the loans is able to create an assignable instrument that is sold to third parties. And as I'm sure you're aware, those interests or those trust certificates are sold over and over, sometimes up to 20 times. The ownership interest in that trust may change many, many times, and this is usually the case in a majority of the cases we have audited. It's important to know that as a mortgage passes from one of these entities to the next, from the originator to the financial institution that pulled the loan, to the depositor, to the trusts, each of those represents an assignment of the note. At each one of these occurrences, the note should have been endorsed over to the new owner appropriately. This means that an officer from the company making the assignment would have needed to sign a note with the notarized signature. In most cases we have seen, there was never an officer or any proper endorsement. These things never took place, so in fact the trust never got valid possession of that note. In some cases it was done correctly, but in the audits that we do, we very rarely find a trust that has legitimate ownership of one of these notes, and that's a major piece of this puzzle. So exactly what went wrong with securitization? The transferability of an asset plays a major role in its value. The ease and ability to pass ownership of an asset from one party to the next, or the liquidity of that asset plays a major role of what somebody's willing to pay for. The trust created under the New York trust law that owned these pools had very specific acceptance and transfer requirements for the notes. These requirements slowed down the process of creating signed trust certificates because there was a lot of paperwork to be completed in the process. As a result, the major players in the industry created MERS. That stands for Mortgage Electronic Registration System. In this system, each loan got what was known as a MIN, Mortgage Identification Number, and was transferred within the MERS system when sold. What this meant was instead of the appropriate wet ink signature endorsement happening each time ownership of the note transferred from one entity to the next, all that happened was the entity that was registered to MERS changed. The upshot that the mortgage transfer requirements mandated by the New York State Trust and by local laws were intentionally ignored and broken by these lending institutions in an effort to turn over these transactions as rapidly as possible to create as much profit as possible. Now, what can this mean to you? If the note is not validly held by the party foreclosing on you, you may be able to permanently stop them from foreclosing, period. I want to repeat that. If the note is not validly held by the party foreclosing on you, you may be able to permanently stop them from foreclosing, period. If you're not in foreclosure, you may still be able to file a suit and may have other remedies that can put you in a powerful bargaining position if the bank doesn't have the right to your payments. By becoming informed and building a powerful suit of evidence, you can gain the upper hand in negotiations with your lender. Whether you're trying to achieve modification or stop a foreclosure, being informed and knowing your situation makes a huge difference. If you do decide to file suit against your lender, Property Solutions Center recommends that you do so by the skills of an attorney that's familiar with litigation against mortgage lenders. On the 60 Minutes interview, Sheila Bair of the FDIC Chairman Committee stated that there were about 30,000 of these cases going on right now. So obviously there's a significant number of people stepping up and using this type of platform to litigate against their lender. The next thing is success stories. There are consumers that have taken on their lenders and won the war. Courts are now starting to see that there have been patterns of systematic abuse of the foreclosure system by the lenders, and they are now hearing cases about homeowners standing up and saying, "This bank doesn't even have a standing in this court of law."